Hi, my name is Zach Crosner. I'm an employment lawyer. I have an award-winning law firm, and I've been recognized as a top 40 under 40 lawyer. In this video, I'll be discussing constructive discharge, including what is constructive discharge, who qualifies for constructive discharge, and some of the strategies around proving it. A number of employees in California and the United States are forced to quit their jobs as a result of the unbearable conditions in the workplace. So, what is constructive discharge? According to the California Supreme Court, constructive discharge occurs when an employee's actions directly cause an employee to quit their job. Even though it's the employee who says, "I quit," in actuality, it's the employer's adverse conduct or failure to resolve intolerable working conditions that forces an employee to resign their position. Therefore, it can be said that the employer constructively discharged or fired the employee. So what are intolerable working conditions? Intolerable or unbearable conditions can come in many forms. Most lawsuits that have been filed in California have involved situations where the employee was subjected to some type of unlawful conditions, such as discrimination, harassment, or a hostile work environment. But it can also be related to other forms of mistreatment, such as an employee being paid less than their coworkers or being forced to work from a new company location much farther away. How do I prove constructive discharge in California? The first thing to know is that constructive discharge can be very difficult to prove. For an employee to prove constructive discharge, the employee must be able to prove, one, that his or her working conditions were so intolerable that any reasonable employee would resign from this job, and two, the employer had knowledge of the unbearable working conditions and knowingly permitted them to continue, or that the employer had the intention of forcing the employee to quit his or her job. One tip that can make an employee's case significantly more provable is if the employee reports the intolerable conditions in writing to his or her employer. A writing can be anything such as an email, text message, or even a letter to the appropriate person. The appropriate person can be human resources, the legal department, a supervisor, or even the owner in some circumstances. You should also consider keeping a contemporaneous journal with dates describing the intolerable conditions. Essentially, the more documentation, the better. A second tip is that the closer in time between the unbearable working conditions, or when they were reported by the employee, and the time the employee quits his or her job, the more provable that it was these conditions that were the direct cause of the employee's resignation. There are multiple additional strategies to know. So if you're facing unbearable working conditions and are considering quitting your job, I highly recommend you contact a lawyer. My law firm, Crosner Legal, offers 100% free consultations to any employee in this situation. So what is the deadline for filing a wrongful constructive discharge suit? In California, you must file your constructive discharge suit before the statute of limitations has expired. There are several statutes or laws that you can include in your lawsuit. Each of these has a unique statute of limitations in order to obtain the most damages, which we'll discuss later. You will want to incorporate a violation of the Fair Housing and Employment Act in California. Generally, you have 1 year from the time you quit your job to file a complaint with the Department of Fair Housing and Employment, and then 1 year from then to file your actual lawsuit in a California court. It's also very important to mention that federal employees must file with a different organization called the EEOC within 45 days of termination. You can find links on where to file these complaints by going to my law firm's constructive termination blog, which will be in the notes to this video. Notably, there are other statutes that permit employees to file a constructive termination claim without filing lawsuits within a 1 year period. These can be filed within a 2-year period, and they include wrongful constructive termination in violation of an oral contract or in violation of public policy. You can also file a claim under wrongful termination whistleblower that can be filed within 3 years of an employee resigning from their position. Okay, so I'm sure what you guys are all wondering is, what can you actually get out of a wrongful termination lawsuit? In other words, what damages can an employee recover when they allege wrongful termination in a lawsuit? The most common form of damages include 1, back pay, and 2, emotional distress. Back pay means that an employee can receive the amount of money they were making or their salary from the time of termination to the time of settlement or verdict. So for example, if you were making $3,000 per month and it took 3 months to settle your claims, from the time you quit your job, you would be owed $9,000 in back pay. However, back pay can be a double-edged sword. What I mean by that is, on one hand, you have to prove that you were able to work during the period that you had been terminated, but also, on the other hand, if an employee obtains employment, their back pay is cut off at that point. So, using the last example, if you were fired and then 2 months later obtained employment of equal or more pay, even if your case doesn't settle for another year, you would still likely only receive $6,000 in back pay. The second most common form of damages is emotional distress. This occurs when an employee experiences severe psychological distress following their constructive termination. An employee should maintain any and all documentation in this regard as evidence. Common forms of proof would be physician notes, any medication that they were prescribed, or other aggravating circumstances such as losing their apartment lease because they were unable to afford rent. The last thing I want to talk about is how constructive termination can impact unemployment benefits. Employees who voluntarily quit typically do not receive unemployment benefits and also generally lose their right to sue a company for wrongful termination. However, workers who lose their jobs as a result of constructive discharge may in fact apply and receive unemployment and retain the right to sue. This is because the resignation was technically voluntary, and so they can be considered terminated under the law. Okay, that's it for today. Again, my name is Zach Crosner. I'm an employment lawyer with the law firm Crosner Legal. If you're interested in learning more, please check out our employment law blog. And if you would like a free consultation from an experienced lawyer, please give us a call at the following number. Thanks so much.